Hi friends, Tony DeWitt here, Missouri appellate attorney and a guy who likes to make the law make sense on YouTube. Here's what we're discussing today. There's a phrase you may or may not be familiar with. The good Lord giveth, and the good Lord taketh away. The same can be said often for courts, in that they give us and they take things away from us. And sometimes it's possible to lose the case and win a better result than you could have gotten in court. And other times it's possible to win the case and lose and get the result you never wanted. Now, I'm not sure if Andrew Bailey gets up in the morning just hoping to keep innocent people in prison, or whether he's just a stickler for the procedural law of Missouri. I don't know enough about him to know which way he goes, but his actions in the Christopher Dunn case are interesting. The statute that governs the review of criminal convictions and the ability to petition long after post-conviction relief is normally available for vacation of the judgment grants to the Attorney General the right to contest and, if necessary, to appeal the findings of the court that grants that release and vacation of conviction. The ability to contest things by the Attorney General is not necessarily a bad thing. For one thing, it prevents collusion. Somebody who knows somebody passing somebody a large bundle of cash under the table saying, "Hey, can you get my kid out of the joint?" Something like that. It ensures that the public safety is protected and that the evidence that is presented and relied on in that proceeding is valid and useful evidence. We don't want dangerous people out of jail. We want to keep them in jail if at all possible. But the worst thing that can be is to have an innocent person in jail. And when an innocent person has been in jail for 30 years, as far as I'm concerned, that's a 5-alarm fire. And it needs to be dealt with the same way you deal with a 5-alarm fire. The individual prisoner can't bring an action under this statute. That action has to be brought by the prosecuting attorney and the office that actually did the conviction. Several prosecutors' offices in Missouri have formed a conviction integrity unit, and the conviction integrity unit takes what amounts to appeals from prisoners as well as their people out on the other side who are trying to help them, and it looks at the quality of the conviction, and it can determine or at least recommend to the prosecuting attorney to work on this through this statute to get the conviction vacated. Now, what makes that interesting is that one certainly assumes that the prosecuting attorney's office that put the person in jail might very well have a vested interest in keeping them in jail. So when they instead go to the other extreme and try to get them out of jail, we really ought to pay attention to that. Now, you may recall the other day that Mr. Bailey petitioned the Supreme Court for a writ to prevent the release of Christopher Dunn. And they granted that writ or a stay temporarily. He said that he did that because he intended to pursue the appeal, and he pointed out that in his briefing that the decision wasn't final yet, that the appeal could not be filed yet, that while he had filed a notice of appeal, it wouldn't be active for another 25 days. And he pointed out that the circuit court judge who ordered the immediate release did not have the authority to do so, and he cited some good procedural law as well as some good case law to address that argument. And he was right. Let's take a look at the opinion now. This is State ex rel. Andrew Bailey versus the Honorable Jason Singheiser, who was the circuit judge who ordered the immediate release. The Attorney General seeks a writ of prohibition preventing the circuit court from ordering Christopher Dunn's release from custody. Because the circuit court lacks authority to unconditionally release Dunn while criminal charges remain pending, this court issues a permanent writ prohibiting the circuit court from ordering his release without allowing the state of Missouri an opportunity to indicate its intent, if any, to retry Dunn. So in 1991, Dunn was convicted of the murder of Rico Rogers as well as other criminal offenses. The court entered judgment sentencing him to life without parole and consecutive sentences of 90 years. In February 2024, the circuit attorney filed a motion to vacate Dunn's judgment, pursuant to Section 547.031. The Attorney General entered his appearance and opposed the Circuit Attorney's request for relief. The Circuit Court held a hearing on the Circuit Attorney's motion. On July 22nd, the Circuit Court issued a judgment sustaining the motion, vacating Dunn's convictions, and ordering his immediate discharge from custody. The Attorney General immediately filed a notice of appeal to the Court of Appeals. After Dunn remained incarcerated in the Department of Corrections, the Circuit Court on July 24 issued an order directing the Department of Corrections to release Dunn by 6 p.m. that day. Immediately following the entry of this order, the Attorney General filed a petition for a writ of prohibition or mandamus to prevent the Circuit Court from ordering Dunn's release. The Attorney General also requested an emergency stay to allow sufficient time for this court to consider his writ petition. This court issued an order temporarily staying the Circuit Court proceedings and directed expedited briefing from the parties on the merits of the Attorney General's writ petition. The court has jurisdiction, and they go through the reason why you get writs, and then they say the disposition of the Attorney General's request requires interpreting Section 547.031, a recently enacted law allowing the prosecuting or circuit attorney to seek to vacate or set aside a criminal judgment and sentence. In full, Section 547 provides, and they go through the statute. We don't need to go through that here. The Attorney General contends this statute authorized his appeal of the Circuit Court's judgment vacating Dunn's convictions. He argues a writ is warranted because his pending appeal in the Court of Appeals acts to stay the Circuit Court's judgment, and Dunn, therefore, must remain in custody in the Department of Corrections during the pendency of the appeal. Contrary to the Attorney General's argument, the pending appeal does not automatically stay the Circuit Court's judgment. However, as discussed below, the Circuit Court lacked the authority to unconditionally release Dunn instead of remanding him to his pretrial detention status. This court has held that proceedings under Section 547.031 are a collateral attack on a criminal judgment and sentence and are civil in nature. Rule 8109 broadly applies to civil proceedings and provides for the circumstances in which an appeal stays the execution of a civil judgment. Subdivision A1 provides an appeal shall automatically stay the execution of judgment in certain enumerated cases not relevant here. Subdivision A2 provides for the filing of a supersedis bond to stay the execution of a judgment. Rule 92 governs actions seeking injunctive relief, and Rules 92.03 and 92.04 provide that either a circuit court or an appellate court may stay injunctive relief pending appeal. This court need not decide which one of those rules is applicable to the Circuit Court's judgment. Regardless, both rules assume a well-settled principle applicable in all civil proceedings. A judgment is operative from the date of its rendition. The right to execution follows immediately. And they go through and cite a number of cases. Thus, as assumed by these rules providing the authority and conditions for a stay of a judgment, an appeal does not automatically stay the right to execute a judgment that follows immediately from its rendition, absent some legal authority to the contrary. Likewise, an appeal from a final judgment in a criminal case does not automatically stay the execution of such judgment, absent some legal authority providing for such a stay. Here, the Attorney General does not point to any applicable authority providing for an automatic stay of a judgment entered pursuant to 547.031. The judgment in this case, therefore, is immediately operative and enforceable. While the Circuit Court's judgment is not automatically stayed during the pendency of an appeal, the Circuit Court clearly lacked the authority under 547.031 to unconditionally release Dunn from custody. Section 547.031 provides only that the Circuit Court may sustain a motion to vacate and thereby vacate or set aside a criminal conviction. It does not provide that the court may order a defendant's release from custody. Instead, as with any vacated conviction, the criminal case and the charges as to which the conviction has been vacated are reinstated, and the defendant is remanded to his detention status prior to conviction. In such cases, courts typically set a deadline by which the defendant must be released from custody unless the state states its intent to retry the defendant before the deadline. While charges remain pending against Dunn, the state is free to retry him. Of course, the state may elect to dismiss the pending charges or agree to Dunn's release while the pending charges are resolved, or the circuit court may elect to release Dunn on conditions pursuant to Rule 33. What the court lacks, however, is the authority to unconditionally release Dunn from custody under 547.031. This court issues a permanent writ of prohibition commanding the circuit court to vacate its order, directing the Department of Corrections to release Dunn, take no further action to unconditionally release Dunn, and basically, due to the nature of the circumstances and to prevent further delay, the court enters a permanent writ without further briefing or argument. No 8417 motions shall be filed in this matter. That's a motion for rehearing or re-argument. And the clerk of the court is instructed to issue the mandate immediately. Normally, it issues 30 days later. The clerk is instructed here to do it immediately. Would you care to take a guess who it is that makes that determination as to whether to retry him? Yeah. It was the prosecuting attorney's office that filed the motion to get him out. So about 4 hours after the ink was dry on this opinion, the prosecutor notified the court that there was no intention whatsoever to retry Mr. Dunn for any offense, and he was released from prison. While Mr. Bailey can put this writ victory into the win column for him, what he sought to do, which is keep Mr. Dunn in prison longer so that he could appeal the judgment, that's not going to happen. And I doubt very seriously if Mr. Bailey will actually go to the trouble to appeal the decision, although he certainly could. And I certainly don't think that an appellate court would be open to that particular outcome. The wheels of justice usually turn very slowly. In this case, in order to get an innocent man out of jail, the Supreme Court acted with great expedition, as they should have. Mr. Powell on the court wrote an excellent opinion, and the court was unanimous in siding with that opinion. And at the end of it, he threw Mr. Dunn the biggest bone he could throw him. And as Paul Harvey would say, that's the rest of the story. Well, that's what I have for you today. Thank you so much for watching. If you have the opportunity today, go out of your way and do a kindness for someone. Doesn't have to be a big kindness, just something to make their day. Then, when you're done, come on back down here, join me at the beach, and we'll talk about something else. If you like this video, here are a few others you might try, and don't forget to subscribe. Have a terrific day, guys.